let's start.
Just a second.
Sure.
Yes, now we can. So good evening, everyone. And thank you very much for joining today. And for a very long time, we've been waiting to conduct this session. And today we have a fantastic group of people from Trimber Law Firm. It is a boutique law firm based in Bangalore, Mumbai, and Delhi NCR. The firm primarily deals in corporate law, merger and acquisition, arbitration, and alternate dispute resolution, corporate litigation, and technology law. Rest of the introduction, I'll leave it to Gagan and the team. But we have invited them today to enlighten us in this area, very important area for all the investors, the startup investments, and what kind of framework is around there in startup investment. What kind of things, what are the important points as an investor we should be careful of. So I'm very, very sure it's going to be really interesting session today. I'm very excited about it. Thank you very much, Gagan and Akash and Abhinav for kindly agreeing to do it for our club. Over to you, Gagan. Thank you.
Thank you so much, Atul sir. And it's wonderful to be on the other side this time. Every week I am on the other side. It's wonderful to meet everyone. So we have gone through a so-called blind bull run, and now we are in a space where we have to be very cautious with our investments and make money. The other aspect of investing and making money can also be investment in startups and companies.
And thank you very much for joining today.
Sir, I think there is a video, there is a YouTube.
Okay. No, it'll work fine. Please continue.
Okay, thank you, sir. So, so just basically talking about Triangle Law, the firm was founded 4 years back by Anubhav in Bangalore. The basic idea was to provide experience of a tier 1 law firm and qualities of a tier 1 law firm to at a price that is much lesser, and however not compromising in any sense on the quality. The people that founded the law firm, the people that are working, have experience in international law firms and magic circle firms, top tier law firms of India, and got together just to get a hang of the market and just to get make inroads into a market which has a lot of potential, especially the startup market, which was 4 years back in Bangalore. Eventually the firm moved on from Bangalore to Mumbai, and now, as you all probably know, I have now come on board to take forward the NCR operations. I would our core competencies are corporate law, mergers and acquisitions, international arbitration and ADR, strategic dispute advisory, dispute management, litigation in general, and technology and data protection laws. The team, as it stands, Anubhav Sarkar is with us. He's the founding partner, Akash Parihar being the partner, myself being associated partner, and Mr. Panduranga is our senior consultant in corporate advisory matters. I would now hand over to Anubhav. Anubhav, if you could take it forward.
Hi. Thank you for that introduction, Gagan. And it feels nice to see everyone on an evening after a work day. Definitely talk about work, and talking about private equity and venture capital and startup investment. When I do this, I feel like Elizabeth's sixth husband. I know what is expected from me, but I don't know how to do it differently. But I'll try my best today, and I'll try to casually try to not make it academic and try to shed some light on the intricacies that go on and that we see. Because what we have to understand is that the Karnataka government was the first government that first came up with a plan to essentially, after, of course, the liberalization that we had in '92, and when most of the sectors opened up and, most of the sectors had less scrutiny at that point of time, we had, a certain boom in terms of, foreign investment coming in, companies acquiring less traditional forms of investment or working capital to make sure that they grow. And that was the idea. The trend, as we know, of course, started in Silicon Valley in San Francisco, and it was a great hit there. It became a tradition. Now, what was good for Bangalore, or what was good for the state of Karnataka, was low cost of land, was a low cost of basically resources that was available there, and of course the fantastic weather, and of course the beer. So all of that together came together and sort of created an amalgamation of prospects that people tried to venture into, and the government really helped at that point of time. And with the help of the government, there were several of SEZs and so on and so forth that were started. Okay, now this is just an overview of what private equity or venture capital transactions can be. I mean, I'm not even touching the surface of it. Okay, now what happened through this process, what we have to understand is that we moved from a service-driven industry to a innovation-driven industry. What do I mean by innovation-driven industry is essentially that, we were having bright young minds coming and, trying to figure out something which nobody has ever thought about, and trying to reach out to people who have that kind of money to expand, grow, and give to the community at large a service or a product which can be essentially useful to take the market forward, or take the beneficial, or make our lives easy. As we stand in a metropolitan city, the transformation we've had since the 90s to today, as you can understand, is a huge addition of technology. Like today, we can sit in the confines of our house and we can order everything. Okay, in certain states, you can do that with alcohol as well, which is great. So we can sit down in our house and we can do everything. And that is what this innovation, this disruption essentially got to us, right? What we have to understand that to cross from 1992 till now, India, in terms of investment, or in inculcating the culture of investment, is basically the third after US and UK in terms of attracting investment. Now, it is not easy. If you look at the UK-India investment, the number is much higher. If you look at the UK-India investments, inbound investments, the amount is similarly starkly high. We do a lot of conjoint investment as well under the bilateral investment treaties that we have with UK and US. But that's a separate kind of investment, and we will not be going into that today. Today, we'll be dealing with investments which are private equity and venture capital in nature. So without further ado, with that introduction as the background to what we think form the basis of this discussion today, I'll be trying to explain certain primers on what constitutes a basic lifestyle of an investment in a startup, and what will follow are the basic frameworks: step 1, step 2, step 3, step 4, and then what happens after the investment. And after that, in the event that there is any dispute or any discrepancy between the investors and the investee, how those situations are tackled. Okay, the idea, of course, would be to make it less academic and more interactive. What I would definitely appreciate is, at any point of time, please feel free to shoot questions, erratic or non-erratic, to the point, or to what we are speaking about or not, doesn't matter. It only gets better with better conversations. Okay, Gagan, if you can just if you can move the script through. Yeah. Okay. So we will going to bifurcate the investments that happen in startups in terms of the ticket sizes. What I mean by the ticket sizes is essentially the quantum that you're going to invest, or the amount of investment that a startup is looking at, ideally, right? So there is the pre-seed that we call it. Why is it called seed? It is intrinsically, you will find it in a book which is called Michael Shelbourne's Idea of a Business. The idea of coining it as seed essentially means that the initial watering that it needs to germinate into a much bigger and broader plant so as to help the society at better. So it's pre-seed stage. That means it's prior to the growth stage. Okay, in a pre-seed stage, what you will notice is that the money that comes in is essentially from friends and family and founders. Okay, and when founders are putting in their money, okay, the business is called bootstrapped. I'm sure everybody knows. And then there's friends and family round. The pre-seed funding stage is also called friends and family round. It is less formal. When you're entering into documentations, the rights and the liabilities that you negotiate with your friends and families, although you want to make it keep it as a formal process, is less formal. It is somewhat much more lenient, because that the person, they will not face any opposition. At the first instance, they're investing the money primarily due to the reason that they must be having that amount of leeway money to put into that business, and hoping that that some return comes back in accordance to the transaction documents. Okay. However, the ticket size of these transactions are essentially low. It can range anywhere between 5 lakh. Zero. It's not essentially zero, but 0 to, let's say, 50 lakhs, 60 lakhs. This is normally the ticket size that we call as pre-seed stage. Of course, it's a very vague frame that I'm giving you. It can go up to any number depending on what is the quantum and what is the business that the startup or envisaged company that we are talking about is into, right? Then we come to the next stage. Now, this period of a pre-seed stage, in normally our experience, rests somewhere between 6 to 18 months, depending again on the size of the company. So if the company is successful, what we will notice is that there's a period of the funding that they acquire in the pre-seed stage normally lasts for a period between 6 to 18 months. If the trajectory of the company is fine, within the next 18 months, ideally, they should be going to raise the seed funding round. Okay. Now, different startups are in different sector, from SaaS to etc., have different targets in this stage. The most common target across sectors for the seed funding stage is market research and subsequent launch of the product, their primary product. Okay. A primary product is intrinsic to the company's future growth. And why is that is something that we try to understand in the next stage of of investments that I'm going to discuss with you. Okay. In the seed funding, it is normally you will get one HNI, two HNIs, or a group of HNIs coming to invest. The ticket size can vary from anywhere between, in Indian currency, it can vary anywhere between, let's say, 50 lakhs to what we have seen somewhere around 7 crores. That's $1 million. That's normally the ideal range that you would look at. Again, these ranges are something that is extremely vague and we can't really adhere to it, but this is the normal ballpark figure that I can assign you to, right? Now, this is an extremely crucial position where you can actually judge what is the position of the company, what the company, whether the company will make it, whether the company will not make it. And these few months where the money in terms of the seed funding stage comes in determines the prospect of the angel investment stage. Angel investment stage, as we might have heard, the Series A, Series B, Series C. Now, what do we mean by Series A, Series B, Series C? Okay, what we have to understand is that once we survive the seed funding stage, that might be again a period of, depending on what the company does, what kind of business they're into, what sector they're into. It might vary again from 6 to 18 months. And 18 months is a very, very lenient approach. Okay, normally people burn out the money between 6 to 9 months, 10 months in our experiences, and they would want to go into the next phase of their growth of the company. Having said that, coming back to where we were, that Series A phase, 46% of the startups, and this is not a data that I'm throwing just for the sake of it, it has been calculated by NASSCOM and all of the startup integrator or warehouses and it's out there. 46% of the early stage companies, I don't like to call them startups, I like to call them early stage companies. 46% of the early stage companies make it to this stage. If you have made it to this stage, it is commendable. Okay. And this position is primarily, you will be able to come to this position when you have a reliable revenue stream, when you can show the investors a pool of long-term benefits, and a proven track record of growth. The track record on times of growth, which is a good metric to keep in mind, is user base on day one and user base on the day of wanting investment. That means the number of customers or the number of subscribers to the platform, whatever the service that they're or the product that they're trying to provide, right? That is a good metric. What also might be a good metric to analyze is essentially that whether or not you have a genuine revenue stream that is coming in from this entity that you're looking to invest in. If both of these are in affirmative mostly, and the company that you are trying to invest in, and you've done a due diligence, which of course I will come towards later on, has a good governance. And what I mean by good governance is best practices in terms of corporate, which is extremely important for any investor to be aware of, at least the basics of what constitutes good governance in early stage companies, to make sure that all basic documents, information documents, accounts, corporate secretarial records, so on and so on, are in place and how they should be. It's a good green tick off, in terms of the first impression that you might form for this entity that you might want to invest in, right? Again, if you have made it to Series B after Series A, commendable, absolutely commendable. And why do I say that? Because after 46% of the permeability in Series A, Series B, we see a lesser permeability, because most of the companies stagnate and go beyond and keep at that level for a period of time, and they become absolutely complacent in their own revenue stream, and either they don't want to raise funding, or they are not out there, and they're not out there with what they are supposed to be doing, and they disappear. At this stage, it is extremely crucial to also analyze that all the businesses as an investor should be completely verified. Like if you're investing in a company which is in the sports sector, okay, which has an iota of doubt in terms of whether it's involved in some sort of game of chance and game of skill, so on and so forth, we have to keep in mind that these instances, okay, should be looked into by the investor prior to hand and in detail. Okay. Now, Series C is of course the developmental phase of the startup. Okay, it involves the presence of private equity funds. Okay, for after the company has proved its worth in the market for a considerable period of time, and now it is in need of more funds to introduce more products and commodities in the market based on the client acquisition, service, subscriber acquisition, or the prior products that they have generated in the already existing market. These are the three forms of normal investment now that we see. Okay, companies which go beyond that are normally companies which you will see and which are of course prior to the stage of IPO, that is an initial public offering, of which of course all of you know much more about than me. They are in a stage where they will for sure reach the unicorn status. A unicorn status is basically 1,000 crore company, a 1 billion valuation of company, and which is great, right? Okay, can we move on? Right. Okay. So now the investments that you do for Series A, Series B, Series C, pre-seed, seed, there are different models that you can choose to invest in, right? The most common is the syndicate model. It's basically coming together of a few HNIs or a few investors to form a group of investors, or basically backers. They are normally industry they have an idea about the industry that they're going to invest in. For example, there will be entities which normally deal with food and beverage sectors, and you will have HNIs which deal just with that. Okay, there will be sectors which are doing just in fintech, and you would do that. You normally acquire a shareholding in the company which is more than 5% and get a board seat as well to be able to determine the decisions that are taken by the board as well. So this is that kind of a model where you need that industry specialization to take care, and you invest keeping in mind that this is the very specific niche that you want to invest in. Now, under the aegis of SEBI, we also have another instrument or body vehicles that we can basically incorporate to create funds. Now, SEBI demarcates 3 different kinds of alternate investment funds that can be created. These categories are, of course, divided into 3, as you can see. They are category 1, category 2, and category 3. Okay, category 1 is the lower strata of investment that you make. They normally contain of social ventures, angel funds, infrastructure, venture capitals, and it's essentially you get some sort of investment from SEBI because of the kind of investment that you're making. And these investments can also be industry specific. Okay, the requirements to formulate a category 1 AIFs are fairly lesser in terms of what we'll understand in category 2 and category 3, but there are certain restrictions and requirements that you need to comply with in order to formulate these alternate investment funds. Now, coming to category 2 of alternate investment funds, they include private equity and debt funds. Okay, they normally invest in larger, in the stage which is normally Series B, Series C level, depending on, and then when the company is in the development stage. Okay, here the company is done with some sort of development, and here it is essentially to facilitate the rapid growth and day-to-day operational functions of the company. Now, category 3 of the AIFs is somewhat a different class. Okay, they are normally categorized in terms of short-term investments. Okay, this is for family trusts established, ESOP trust established under SEBI or the Companies Act. Okay, employee welfare and other special purpose vehicles which are created, under the specific framework of the SEBI. Okay, now all of these are different in vehicles by which an investor or a consortium of investors you can choose to invest, okay, in a company in different stages. Like I mentioned, for example, category 2 would be when you are in Series B, or let's say Series C onwards per se, or category 1 would be in lower strata investments, seed, pre-seed. And you can follow the syndicate model in pre-seed, seed stages as well. So these are the different models that you have that you normally follow and you would want to adhere to while investing in early stage companies, like I mentioned. Gagan, if we move forward. Okay. Now, valuation is something very intrinsic, and it would basically cover something that Akash should be discussing after I finish what I want to say. Valuation is essentially twofold. What you have to understand, there are 2 basic methods of valuation that we undertake in day-to-day transactions to essentially analyze what is the current framework or the current net worth, or in bare bone words, how much is it worth, the company, as simple as that. Now, we follow the NAV method and the DCF method. As you might know, the NAV method is the net asset value, where basically you take the fair asset value of, and you subtract the external liabilities that are there of the company, and you also take into consideration the depreciation of those asset products, and you come at a number in terms of the value of the company. Okay. Then there's the discounted cash flow method, where the cash flows are calculated post the deduction of the capital of the essential capital on sale. In day-to-day transactions, what you will see is that the DCF method is the most adhered to method which the investor takes while coming at evaluation. You will see that it is most commonly undertaken, but there is no hard and fast rule, because the mode of valuation that you choose to undertake is basically based on the kind of data that you're trying to accumulate, okay, and what is the data that is available from the company, okay, and what are the industry standards in that specific industry that you're investing in, and what is the kind of information that you're seeking from the company, okay, and so on and so forth, right? Moving on. Now, after you're done with the valuation and you've determined that you're going to invest in the company, you've chosen the vehicle that you want to invest in, you've chosen what round and what is the amount, and you valued the company. It is, in my opinion, the most crucial stage. It is the most crucial stage of investments. How we can, if I can just share a document, Gagan, I would.
Yeah, I'm stopping sharing this time. Yeah, go ahead.
Yeah. Okay. So I'm just sharing this for ease of reference so that everybody understands how the process and how crucial the process can be. I'll request, it's an extremely confidential document, so people not to take screenshots, it's a request. And it is just so that, you understand what I'm talking about, and I'm not going haywire in terms of what I'm trying to say. Having said that, the basic structure of how your due diligence is broken when you're looking at a company is these 5 broad headers. They are corporate records and capitalization, human resources, regulatory and compliance, material contracts, litigation, and legal notices. Okay. Now, what is corporate records and capitalization? So what our advice to any company, if we are representing the company, is that before anybody invests in you, you should do an investment health check of your company. That means before the investor doesn't invest due diligence on you, you yourself should do a due diligence on your company to make sure that there is no red flags at the company there is. And people who are very serious about their company, they make sure that they do it before the important rounds investments they undertake. So in this round, what we try to, when we are representing the investor, what we try to look at is that what is the shareholding pattern of the company, okay? Whether the minute books are followed categorically as per the law that has been prescribed. Whether the statutory registers, everything are at par, okay? They are not doing it frivolously. It is just not a child's game for them. They are taking corporate governance measures as they should be taken, okay? The next comes the human resource activities of the company, which is a very crucial aspect because, companies from each stage, you will have, like, let's say from 10 to 200, 300 employees. We have to make sure that whatever legislations, which are numerous based on the geographical location where the company is based out of at least 10 to 15 legislations are applicable on such a company. It is very, very important to check that, they are in absolute compliance with them, because the non-compliance can also lead to detriments later on, and which might be detriment to the investor who's invested without checking all of that. So we would basically check everything that there is from top to bottom under the broad headings of, let's say, the Employment Provident Funds Miscellaneous Provisions Act, Preemptive of Gratuity Act, Maternity Benefit Act, so on and so forth, that, the normal legislation they are. And what we do is that once we analyze the documents and records of the company, we try to bifurcate the risks in color coordination. Suppose that's something that's a no-go, we color coordinate and say this is red to the investor, that you can't, okay? Then we have amber, green, yellow, green, based on the risk that the company can take, or the risk that there is in investing in the company. Based on these 5 parameters that we normally do a check on, a health check of the company on. The regulatory compliance of the company is basically, to check whether the company, the appointment of the directors were done properly, okay, and whether the share capital and so on and so forth were done properly, and etc., etc. Now we come to the most important last couple of parts, which is material contracts and litigation and legal notice, which I'll discuss after stopping sharing my screen. Is material contracts is basically depends on the kind of business that you're in. So if you're in if you have vendors, you might get into large stake agreements with vendors, service providers, etc., etc. You might have, if it's a real estate intensive business, if you have repositories, in such a situation, you might have high stake real estate interventions. In such a situation, we analyze all the agreements to analyze whether there is anything detrimental in any clause that would cause difficulties to the investor when they, or there is a future dispute that there might be, if there's a clause which is adversarial to the future of the business of the company, so on and so forth, right? And in terms of litigation, is basically, we see that if there are litigations in a certain stage of companies, normally Series C, Series D companies have litigations against them, but we also try to analyze what is the stage of litigation they are in, right? At a stage where the companies higher up the investment ladder, you would definitely see certain kinds of legal ramifications, legal problems, litigations against the companies. But what you have to analyze is that what is the stage of the litigation, and what prospective harm might that litigation or that legal might bring to the company at large. And based on that, we try to bifurcate the decision making of the investor, whether he or she should, or whether it should invest in the consortium or not, right? So these are the basic highlights and the parameters that one needs to keep in mind. As a first-hand primer to what constitutes investment, what is the background of investment, and what are the basic time and methodologies that are used in terms of ascertaining whether yes or no. The next portions of are what we try to portray, what we want to portray to you, contains essentially the types of agreements that are there. And that's extremely crucial, because what we have seen is that there are founders who come to lawyers after they have reached a problem, or investors who come to us after they have reached a problem, rather than coming to us before they had the problem. So it is very important to understand the kinds of rights, responsibilities, obligations that are contained in the different kinds of investment documents that you would ideally enter into as an investor when you're investing in an early stage company. And Akash would take that further. Thank you so much, everyone.
Thank you, Anubhav, for setting up the premise for reaching to a point where I have to discuss the agreements. So, hello everyone, my name is Akash, and I think what we will be looking over in the next few slides will be a bit on the technical point. So if anyone has any specific questions on the technical points, can just stop me, or we can have the questions at the end, whatever works with us.
Yeah, I mean, of course, still, if anybody has any questions before Akash begins, please feel free to, we'll be happy to answer a couple of questions and then maybe move forward till we are. If not, we're happy to continue as it is.
Okay, so if someone has any questions, you can just post the questions right away, or we can take up the questions at the end. I'm assuming we don't have any questions till now. So let's move into the agreements. See, primarily there are two agreements which are looked at when we are talking about investment. One is a share subscription agreement, and one is a shareholders agreement. The term subscription in itself means that you are buying shares from the company. That will be an investment, a subscription. Most of the investments which are done in Indian market, where you want the money to flow into the bank account of the company or the books of the company, you do a share subscription model, which is simply a simple agreement where you are saying that, okay, this is what we are agreeing on. I'm going to pay you, 1 lakh, 2 lakh for subscription of shares, and you're going to issue the shares to me. We have the timelines. We have any conditions precedent if arising from the DD. Basically, if we have not done something, we have not filed for any licenses, you are like, before I put in my money in the company, I want you to get these licenses, or I want you to get these agreements in place. This is the bigger question which comes into why DD is important. Is basically we can set up those conditions precedent and closing actions in the share subscription agreements. And as most of you will be aware, that's the whole crux of doing a due diligence. Basically, we find red flags in the company, but we want to rectify it also before we get into the company. We don't want to be in a company with red flags. So I think that's the whole idea of share subscription agreement. The more important aspect or the agreement which we come into is the shareholders agreement. Because here, as an investor, you become a member of the company. And once you're becoming a member of the company, you have an inter se responsibility to each other. And that inter se responsibility and relationship of each shareholder is governed by the shareholders agreement. And these agreements govern each and everyone's right. But what we have seen in our practice and what is prevalent in the market is when an investor comes, an investor is like a king in these shareholder agreements, because at the end of the day, investor is coming at a valuation where he's adding value to the company by investing and also letting the company grow. So in such a situation, there are certain rights, special rights, which are given to an investor in shareholders agreement. From having the right to appoint a board director, to have restrictions to avoid founders from selling their shares, like transfer restrictions. Then having these rights called ROFO and ROFO, which I'll be explaining in the next slides. Drag along rights, reverse vesting, affirmative matters. These are just like popular jargons you use, or popular keywords you use in every shareholders agreement. But I would try to simplify it as much as possible in the next slide, and it will be like a one-liner for each of these, so we'll get an idea of how we are placed in terms of tomorrow. If we are looking at a term sheet or a shareholders agreement, and someone say, Akash, what do you think about ROFR? How can we understand ROFR? So, hopefully after we go through the next few slides, next time someone asks you what is a ROFR, you'll be like, yeah, we know ROFR because we've been dealt about it and we have read about it. We have discussed about ROFR and how it operates. Okay. Then we go to this agreement called share purchase agreement. Share purchase agreement is mostly a secondary purchase of shares. Someone who is an existing shareholder and you buy shares from them. This is really important in terms of an exit. And when we are looking at the exit, right, I will try to connect share purchase agreement to an exit. That, see, the important aspect for an investor is entry and exit. Because if you are not making the IRR, then what is the sense of making the investment? So that's why exit is important. Then share purchase agreement comes there, but in a lot of acquisition transactions we do, there are two kinds of acquisitions you do. You either acquire the business or you acquire the shares of the company and own the company. So when you are owning the shares of the company, that kind of a transaction is called a share purchase agreement. Then you have a set of agreements you sign with the KMPs. Is basically key managerial persons of the company, stating that you will not leave the employment, you will have anti-competitive provisions and non-solicit against you. Because see, the whole idea of an investor investing in a company is putting a faith in a promoter. Because at the end of the day, whatever we say and do, India is a promoter-driven corporate market, where we look at the face of the company. There's a face of a company. You look at from a unicorn startup to you look at the biggest conglomerates you have in India. We are always a face-driven society. We like our heroes. We like someone who is the face of the company, and that is where we are trusting. And that's the same goes for investor. An investor invests in a good founder and an idea, not just in the idea, not just in the founder. It's a combination of two, but founder is really important. So I think that's the whole parameter while KMT employments are, agreement employments are important. Now, Gagan, can you move to the next slide? Next slide. Yeah. So now we come to now we come to the rights which are there in Gagan. This. Thank you. So now we are coming at the rights in the shareholders agreement. This is where mostly as investors or as founders, we need to be aware of these specific rights, because this is what drive a transaction or make or break a transaction, right? Preemptive right is basically a simple right that if I am the shareholder of the company at the moment and tomorrow company wants to, so for instance, I will give you a simple example of preemptive right. Preemptive right is before company issues new share and get someone on board, they should offer these shares to me also in pro rata. So for instance, Gagan and I have a company. I own 10 shares in the company. Gagan owns 90 shares in the company. And tomorrow company want to issue 100 new shares. Out of that 100 new shares, the company should offer 10 shares to me. That is the idea of preemptive right. Are we clear? Does anyone have any question on preemptive right? It's very simple. It's basically if company is issuing new shares, they will give me a first right to subscribe to those shares in proportion to my shareholding. So if my shareholding is 10%, then 10% of the newly issued shares should be offered. There's a preemptive right. So as a preemptive right, it's a right but not an obligation. That's the language you put. Basically, I can subscribe, but I can tell that I won't subscribe also. But I have that right, and you, as a investor, you want to have this right. Then we have this, combination of two rights, which are either or. You have right of first refusal and right of first offer. These are the most common words you always talk about, ROFR and ROFO. ROFR basically means that I have the right to refuse. So preemption only works in terms of when a company is issuing new shares. But right of first refusal works when one of the existing shareholder of the company want to sell their shares to someone else who is not a member of the company. So before you sell those shares, you have to offer it to me, and I have a right to refuse those offers. That is called a right of first refusal. So I can accept or refuse that offer. Then you have right of first offer. So right of first offer means that if you are selling tomorrow, you say you come to me and I will make an offer to you. So why would someone prefer right of first refusal and right of first offer? That's an interesting point, because when you are doing right of first offer, you have to do all the market research, determine the price, make an offer document, make a formal offer to the seller saying that, okay, this is the offer I am making. Can you sell your shares to me? But when you have right of first refusal, the whole hard work, the whole process and hard work has to be done by the seller. So he will do the market research, he will come with the price, and he will tell me, okay, this is the offer I am placing it to you. I am planning to sell my shares, and this is the offer I am making you. You can either accept or reject. So this is the idea why, as an investor, I will always suggest you to stick with ROFR and don't go for ROFO, because then, see, if the promoter is selling, it's easier for him to do the market research and determine the price. Otherwise, if you are the one who has ROFO, you will have to do all the market research, look into the document, get an independent valuer to value the company. So it's a lot of work. So as an investor, always makes sense to stick with the ROFO. Now we come to the next point of board rights. So board rights are simple: whether I have a right to appoint a director or an observer on the board of the company, depending on how much shareholding you are holding in the company and what presence and what importance you have so far as on the board is concerned, and how your interaction with the founders are. Because I have seen board seats at 5% also. I have seen board seats not given at 10% also. So it depends on what value the investor is bringing on the company. But the idea of having a board and an observer is basically to make sure that whatever has been done in the company, I am aware of it as an investor. That's the whole idea. A lot of investors don't go for directorship. They generally appoint an observer because they don't want that extra added obligation on them. Because once you become a director, there are a bunch of responsibilities which are put on you. Even though you are a nominee director, but still there are responsibilities. And so basically an observer is an easy way out, which a lot of investors are taking lately. Okay. Now we have this interesting aspect or rights called reserve matters or affirmative matters. So these are basically a list of actions which cannot be completed without the consent of the investor. Something like this is done in a manner where you provide a structure where that any decision which the company is taking, they will have to get a consent from the investor. Because I think the startup market drives these rights, because a startup market where a founder has the idea, he doesn't have the capital, and the capital is provided by the investor. So it gives them the right to protect their capital and make sure that none of the stupid decisions are being taken by the founders. So in such a situation, affirmative matters become a huge decision. Like, for instance, I can give an example of affirmative matter. Well, something like the business plan has to be approved by us. The audited financial statement should be showed to us and approved by us. Any new business you are starting has to be approved by the investor. If you are hiring someone on a VP level or someone who is getting paid more than 30 lakhs, has to be approved by us as an investor. These are few rights which I'm talking about. For instance, tomorrow company wants to give dividend. A company wants to go into liquidation. Company wants to merge with someone else. So I, as an investor, should have the right to veto these matters, saying that, okay, you cannot compete, you cannot merge with a competitor, you cannot merge with, or you cannot get an investment from someone who is a competitor to me as an investor. So these are the points where you have to protect your interest. And while protecting your interest, affirmative matters and reserve matters are really important. Okay. Then I think the last model where we come at is transfer restrictions. And transfer restrictions is simple. It's basically ROFO and ROFO are also kind of a transfer restrictions. The idea is, if I'm investing in a company, I'm investing in the founders. And tomorrow, if the founders leave, what am I doing with the company? Who will run the company? I, as an investor, don't want to run the company. I want to make my money. I want to make profits out of it at the end of the day. That's what I have been looking at. And that's why transfer restrictions are there. That's why you have vesting of shares, where you lock in the shares of the founders when you invest in a company. That is the whole idea. So transfer restrictions are really, really important. Transfer restrictions kind of gives a like a support mechanism for the investor, and also a safeguard to them, to be honest. Is basically the founder who will leave. Because if transfer restrictions are not there, tomorrow one of the founders leaves and sells it to any third party, and that third party wants to merge this, and you're not getting anything as an investor. So I think that's one of the reasons why transfer restrictions are really important. Gagan, can you move to the next slide? Yeah. Now, I think, so first we have discussed how an investor enter into a business. Now we talk about how an investor gets out of the business. So the first and the simple way is basically making your big buck at the initial public offering. If it works out for a startup, IPOs are the great way to make money. A lot of investors in the early 90s made a lot of money in terms of IPO. Biggest example being Bharti, the Airtel group. So that's the first strategy, where you're looking for an exit. You're looking for an exit via an IPO. In the event, and I don't have to explain how IPO works because all of you are aware of how IPO works. Then if IPO doesn't work, which is very common in the current startup market, because if they don't have a steady revenue stream, as well as the amount of investor funding which has been put forward, they are just looking for scalability and not looking at revenue. So if in the event IPO doesn't go through, there's this option called third party sale. Third party sale or a strategic sale basically means that you as an investor will ask the company to give us an exit, get a buyer for me at a price, and if you don't get a buyer, I will sell it to someone else. So that's a third party sale. Third party sale is basically the company or the founders have to find a buyer and buy me out of the company, because I want to get an exit, I want to get my return, I don't want to be stuck in the company. Okay, and this is generally after 7 years, 8 years into the company. Excuse me. Then in the event the company and the promoters fail to provide you a third party sale, you have this right called, where you say that you have failed your obligation to provide me an exit. What I will do is I will sell my shares and I will drag you along with me. What drag you along me means is basically I am selling my shareholding, and because if I am holding 20% in the company, if someone is coming, they want to run the company also. So I will drag you along with me. I will drag you along with me basically means that if I am selling my shares, I'll make sure that you also have to sell your shares and the whole company is getting acquired. And in such a transaction, we execute a share purchase agreement. So linking in the share purchase agreement to this point, where, in such a transaction, you do a share purchase agreement and all the investor along with the founders are removed from the company, exited from the company. That's called a perfect exit, which is dragged by the investors. Then you also have a tag along right. Tag along right will be like tomorrow the investor sell their shares. The founders sell their shares and the investor is like, oh, you are leaving the company. You own 80% of the shares. You are leaving the company. What will I do with 20%? You give me a tag along right. Tag along means is basically something is moving. I'll just tag along with that moving thing and step out of the company. That's the whole idea of tag along. Just tag, simple tag. I'll tag with someone and move on to the company. That is kind of a brief summary of, what you do when you enter into a company as an investor, what are the rights you look for as an investor in a company, and how you exit the company. These are the 3 points which I had to, kind of elaborate on in a brief manner. So I hope I have cleared that. Gagan, can you move to the next slide? Yeah. So those were the 3 points which I wanted to focus on. If anyone has any questions, you can ask me. Meanwhile, I'll hand it over to Gagan to, handle the basics of taxation, as well as, in terms of how ADR and dispute resolution and a deadlock mechanism will work in a situation like this, because deadlocks in startups are a very common aspect. So hand it over it to you, Gagan.
If we have any questions till now, anyone? Okay, I think there are no questions. So yeah, talking basically about why we enter into we have discussed how we enter into a startup. We have discussed what are the agreements. Now, as an investor, the basic is, why am I entering into any trade, entering into any investment? And the basic thing is the profits, or what I take home from that. Now, when I make a profit on a transaction, I also pay tax to the government. There are people who are telling me to remember. There are people who keep on discussing that how taxes should all just go, but we are not at a stage yet, at least, that we can talk about that. So yeah, in fact, till around 2018-19, there was an angel investor was taxed about 30% of the money that he puts into a startup, which was pretty heavy a tax. However, the government came out with the Startup India concept in 2016, whereby startups were recognized along with SME, small and medium term enterprises, and a lot of taxation benefits and a lot of taxation exemptions were provided to these to investments in startups as well as startups per se. So just talking about the investor point of view, first and foremost is that if it is a recognized startup by the government, an angel investor who's investing in the starting stages of a startup can claim exemptions almost to about 100% of the money that is being put into that startup. Now, again, there are a lot of qualifications that have been put in by the government as to which startup that you can enter into and which is a recognized startup for this particular exemption. However, still, that is, if you are investing in a recognized startup as per the government parameters, you have a substantial benefit to gain out of that. It's earlier, as I said, it was only limited to an SME, but now these exemptions have also been granted to investment in startups as well. Looking at the startup point of view, looking at the company point of view, the government came up with a new scheme wherein a 3-year exemption period is provided. In the past 7 years, any startup that has been started from 2006 till 2021, 31st March 2021 till date. However, now it has been extended to 31st March 2022, and any startup taking on an angel investment which has income of more than 25 lakhs in the past 3 financial years and a turnover of less than 100 crores is eligible to a tax benefit and is eligible to benefit of not being taxed on the angel investment that comes into picture. So that's a big exemption that is provided. Now, as it was in the Government of India's notification in 2019, and from there onwards is the reason that now we are seeing more and more money flowing into startups and probably a new unicorn culture being built, which came on in post 2008, and there are around 9 unicorns in India now, and probably with this venture we can probably see new unicorns coming into picture sometime around 3 or 4 years down the line. Now, having talked about the taxation regime, let's just discuss the capital tax or the capital gain and whether they are taxable or not. we all know when we are selling and making a trade, we are liable to short-term capital gains. When we have kept it for more than a year, it amounts to a long-term capital gain, and we are taxed according to our tax slabs and the tax that is applicable on the short-term and the long-term capital gain. However, earlier, as I said, there was no exemptions on the tax when these taxes are put into a startup. However, now the government has also recognized startups for the purpose of long-term and short-term, for the purpose of long-term capital gains. And I'll just take an example of selling a property. And if I've sold a property in the past 5 years, and there is some money that I've gained, there is a long-term capital gain that I've made out of that property, I can invest it into a recognized startup and claim exemption, claim benefits of taxation, benefits of concession taxation from that as well. So that aspect of taxation again makes the money flow into the startup and makes a startup or a startup a very lucrative entity for me to invest my money into. The next thing is the dividend. The next thing, as we know, there are entities which provide dividends. So DDT, or the dividend taxation, comes into picture. Dividend, as we all know, is taxable at source itself, and it is taxed at 15% of the gross amount, which has to be paid within the 14 days of the declaration of dividend. Now, persons who are receiving more than 10 lakhs in dividend have to now pay an additional tax as well on the dividends as well. And that is how dividends are taxed in the country. The taxation that is run on dividends lesser than 10%, 10 lakhs is according to your tax slab. Coming on to the last aspect that we wish to discuss is the dispute resolution, or what happens when there are when there are certain situations that arise where the deadlock has arisen. So prior to the Vodafone judgment, there was a discrepancy or a confusion of whether the arbitration clause in a shareholder agreement is valid or not, or whether, since it's not present in the article of association of the company. However, thanks to the Supreme Court's judgment in the Vodafone Holdings and versus Union of India, it's very clear that even a contractual, even the arbitration clauses that are present in the shareholder agreements are valid, and the contractual view of the arbitration clause has been upheld. So even when these arbitration clauses may not be present, and they are generally not present in the article of association, since these articles of association, if you just search for the articles of association of a nascent company which has just come into picture, it's a very standard article of association. Normally those arbitration clauses are not present. So even if these arbitration clauses are not present, and then there is a shareholders agreement which has a dispute resolution clause with an arbitration clause in it, it would very well be valid. Now, the benefit of this arbitration clause is, we all know, and probably we have faced that problem, that litigation in India goes on for years and years without any result. However, there are amendments in the Arbitration Act. There are mechanisms that are being tried to be ensured so that these disputes can be solved at a very nascent stage. And the Arbitration Act now says that a domestic arbitration has to be decided within a time span of 1 year, extendable by 6 months. So within 1 year to 1.5 years, we can get a result of we can get to a conclusion, and the deadlock can be broken, and that dispute can be resolved. This judicial intervention, the other way is what happens if your investment fails, supposedly. What happens if the startup goes into insolvency? There are debts accruing on the startup, and the debts cannot be paid off. A large investor may try to purchase the startup at a resolution stage, or supposedly a creditor may just invoke an insolvency proceeding against you, which is admitted. Now, when such a thing happens, normally you move to the NCLT, which is the adjudicating authority for all of these. There is a resolution plan that comes into picture, and a large investor which probably still believes in the working of the company and believes in the idea, or probably the product or service that is being trying to sold, tries to take over the company. And when such a thing happens, there are mergers and demergers, and there are resolution plans that are brought in picture. The NCLT approves these plans, and once it's a well drafted, once it's a properly made out plan, the NCLT approves its plans as per its parameters and entitles entities to join together, or supposedly two entities to break up into two or more and go their separate ways. There is the third thing called of an acquisition, where two or more entities may join together. This is also done through the process of approval from NCLT itself, and or it could be through an asset transfer or through acquisition of shares, a third-party share purchase agreement, a third-party transfer, as discussed by Akash earlier as well. There is another thing of restructuring in an M&A transaction, which is governed by the Competition Act compliances, as well as and the CCI also has a role to play in the same. Now, due to paucity of time, probably I would have to stop here in this process. However, I would just make a small observation. I was in court today and was lucky enough that there was a dispute between Reebok and Adidas going on. So, if anybody was following, last month, Adidas finally decided to take its ownership out of Reebok and sell Reebok to ABG Group. Probably there are two views to look at it. Reebok has filed a criminal complaint, and now it's in public domain, so we can discuss about that in the public domain, and trying to sue Adidas for criminal breach of trust and various other criminal provisions. Now, had that share purchase agreement or had that acquisition not been done properly, or there were loopholes, the process would have not reached a criminal court. But the fact that those agreements were tight, those agreements were well drafted, is the reason that today Reebok is going into a criminal breach of trust proceeding and not into a operation and mismanagement thing, to try and prove how Adidas has squeezed out the money and now just pumped and dumped Reebok shares on ABG, leaving Reebok without any management or without any substantial assets. With that, I would open the forum for any questions. If you have any questions, please feel free.
So that was excellent, Gagan and Akash and Anubhav. Just one question, Gagan. You mentioned that the profit that one can get from sale of property can be invested in a qualified startup. Yeah, Gagan, can you hear me?
Yes, sir, I can.
So I was just asking, like you mentioned, that profits from the sale of property can be invested in a qualified startup or recognized startup. Can I invest profit from the sale of my property in my own recognized startup? Sorry, it's a funny question, but.
So, sir, startup is a startup which is registered and recognized is technically a separate corporate entity, and under normal circumstances, if the management is right, if the disclosures are right, there should not be a problem. Considering we will have to consider a lot of factors into picture: who are the directors, who's running the company, who's running the startup, how many directors are present in the startup. On a prima facie, just giving you a prima facie answer would probably be yes. However, there have to be nitty-gritties which have to be looked into to decide whether it is and then also the fair valuation is very important, because any investment that is put into the startup for a tax exemption has to be above the fair market value.
Sure.
If Akash or Anubhav would like to.
Thank you very much. Okay.
I think Gagan summed up like a detailed answer for you in the most lawyer way it can be possible. But jokes apart, the idea of investing in a startup, and I think there are a few questions which we have with basically related party transaction, as well as if you're already a shareholder, whether you can invest the money through rights issue or preferential allotment, something like this. That will be the modalities which have to be worked around. But if the bigger tax question can be answered in an affirmative way, then I think all the modalities can be worked around. That wouldn't be a problem.
Thank you very much, Akash. And I would like to thank you specially to run the shareholding rights and entry and exit modalities. I think that was fantastic. That was real eye opener, and I'm sure everybody must have gained a lot from the presentation. Guys,
Thank you.
anyone
It was
wants
a
to ask?
pleasure to discuss those points. I'm always up for a discussion on shareholders agreement.
No, seriously. I mean, you don't see these kind of things. You don't get this kind of knowledge otherwise. So I'm really, really thankful to you guys. Anyone wants to ask any questions, please, or share your feedbacks.
Yes, hi. Hi, this is Amber. I have a question for Akash. So in a tag-along scenario, does the minority shareholder have to sell his shares to the same entity to which the promoter sold to in the first place?
Yeah, so Amber, to give an answer to your question, in a tag-along situation, what happens is the tag-along right holder gets the same right as the investor and the same buyer and the same terms also. So for instance, if I am the promoter and Gagan is the investor and I am selling my shares for per share for 100 rupees, a tag-along holder will also have the right to sell it for 100 rupees at the same terms. So that's the whole, see, when you are drafting such an agreement, you have to also look at intricacies like this, same terms, which are applicable to the investor or the majority shareholder. So if the promoter being the majority selling it a specific price, I should get the same price. Otherwise, what is the sense of having a tag along? He's selling for 80 and I'm selling for 20, then what is the worth? What is the sense of having the right? So I think, Amber, I hope I answered your question.
Yeah, I just had a follow-up there. So let's say in a scenario where the minority shareholder does not agree to the terms that promoter agreed with to the entity in question and wants to actually sell it in some other way, because now that the majority shareholder is leaving, might as well sell it. So does the minority shareholder have any other right similar to a tag-along right? Or something along those lines to
See, in such a situation, what happens is basically if they don't agree with the terms, then the promoter or the majority shareholder will go on with their sale. The minority can either sell to any other third party which they deem fit, or in the event if the promoter have a drag along right, and if the promoter have a drag along right, the promoter can drag the minority investor irrespective of whatever minority investors or minority shareholders consent is. So that also you have to keep in mind, that whether tag along and drag along are intertwined in this such a situation. If they are not, and if there's no drag along which the majority shareholder have over the minority shareholder, then the minority shareholder is as free as you can be in terms of sale of those shares.
Thank you, Akash. That was quite insightful. Thank you.
Thank you, Amber, for such an interesting question. Anyone else?
Perfect. If nothing else, then I would like to thank all three of you on behalf of Together members.
Thank you, Atul. Thank you for giving this opportunity to speak to such an interactive crowd, and we got an opportunity to speak about what we do on a day-to-day basis. So I think that's a thank from me, but I think Gagan and Anubhav might have a few words to share after.
Well, Atul, thank you so much. I mean, normally when we do webinars, the number that we start with, it ends with a fairly less number of people when we start with. But here, we're glad that we've been able to stuck to the normal, more needed, more like the average number has been what we started with. So I'm grateful for that. These are but intrinsically speaking, what we normally see is that the transactions or the ecosystem of investing in India is a very interesting space to be in. But the thing is that it would be much more interesting if people, or the general consensus, or people who are part of this community are maybe aware of the small modalities of what go into it on a day-to-day basis, and that make the process much more easier for everybody: investors, founders, councils, accountants, everybody involved with the process. And it was just our endeavor to make sure that we break down things to the bare bone as much as we can, and I hope we've been able to do that. If not, what I'll do is that I will share our email address right on the chat here, which is a common email address. And if anybody has any questions, irrespective of whatever, just feel free to reach out to this email address with the reference to this webinar, or just reach out to Gagan, reach out to me. We're available on we have LinkedIn, wherever. Please feel free to reach out, and we'll be happy to answer the questions without our hourly rates. So yeah, thank you so much.
Thank you very much, Anwar. I think you guys have been really excellent. It was very, very informative session. Frankly speaking, I think I've been working in startup area for the last 12 years, but every time I attend one such session, I still learn a lot of it that I think I've never heard. Like Gagan has actually enlightened me, and it's a great news that profit from the properties can be invested in recognized startups. It's absolutely amazing news. I had no idea, Gagan, before today. And I always thought I know most of it. So absolutely amazing session. I'm sure like me, many would have learned something new or many new things today. And guys, let me tell you, the slides Akash covered, you'll not find that kind of knowledge sharing in many places. So if you really want to revisit that whole thing, you can go to our YouTube channel. I mean, it's live right now. And all of you know Together Investing YouTube channel. So you can actually just watch the video again if you want to. And like Anubhav kindly offered, if you have any query, just send them an email.
Yeah, we'll be happy to answer any questions that you might have purely academically, whatever needs to be done.
Thank you very much, Anubhav. So thank you very much, guys, and have a great evening, everyone.